I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
All right, folks. Today's courtroom moment features one of the most clueless sovereign citizens I've seen in a long time. It's 2025. How are these people still around? This guy can't even read, yet he strolls into court acting like a legal genius, thinking he can defend himself. His main argument? He says it's unfair because he only had 1 hour to study the law, while the prosecutor had 7 years of law school. Seriously, that's like entering a marathon with zero training and whining that the Olympic runners had a head start. This is about to be both cringy and hilarious. Drop your thoughts in the comments as we dive into this legal train wreck.
People of the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
Man, this guy can barely read. And now he wants to stand up in court and read his own motions like he's some kind of legal mastermind. Be honest, what would you rank his reading level at? I'd say 6th grade, and that's being generous. But here's the kicker. He's actually upset that he didn't get enough time to study the law. Like, seriously? You think the judge is just going to hit pause on your case for the next few years so you can go earn a law degree? The entitlement is unreal. Back in the day, if you didn't know how to do something, you found someone who did. You didn't throw a fit and expect the system to stop for you. The court's already laid it out. Hire a lawyer, take the public defender, or go it alone, if you know what you're doing. Clearly he doesn't. What's next? Asking for a delay so he can get sworn into the Supreme Court. Let me know what you think of this guy so far. Now let's get back into it.
All right, go right ahead.
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study even after motion, or the judge throughout plea not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions, making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
Is anyone else just waiting for the judge to hit him with, "Nice speech, little guy"? Motion denied? Because honestly, that's exactly where this is headed. This guy didn't need to read his motion like it was the Gettysburg Address. And let's be real, I'm pretty sure the judge only let him go on for the entertainment value. Like, sure, read it. We could all use a laugh. Truth is, judges can shut down ridiculous motions instantly, especially ones that waste everyone's time. And this is a textbook example. Rule 11 of the Federal Rules of Civil Procedure literally exists to stop this kind of nonsense. Courts can hit people with sanctions for filing baseless, time-wasting motions just like this. But maybe he thinks if he talks long enough, the judge will magically recognize his sovereign brilliance and toss the whole case. Spoiler alert, that's not happening.
impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end and deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have a third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this guy actually clueless, or is he just playing dumb? I'm leaning toward the latter, because there's no way someone facing real jail time can be this unprepared. By accident. This isn't a high school pop quiz. You can't just wing it and hope it works out. His entire defense falls apart the moment you remember. He could have had a court-appointed attorney for free. But instead of using that, he'd rather waste the court's time with nonsense motions and then complain he only had 1 hour to study the law. Like, what did he think this was? An open book test? He honestly reminds me of that one kid in class who clearly didn't do the project but tried to freestyle a presentation anyway, hoping no one would notice. Newsflash. Everyone notices. Let me know what you think. Is he faking it or just totally lost? Let's jump back in.
And it states that there's a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And you didn't want that either. So then we went through the hearings. And I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus information. You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
Honestly, I think the judge handled this really well. Sure, she could have shut him down sooner, but then again, we wouldn't have gotten such a hilarious moment out of it. I mean, what was this guy even thinking when he walked into court? Did he really believe he was going to talk his way out of it when he could barely read that crumpled up paper he probably found on the jail floor? This right here is why it's so important to actually understand your rights, not so you can spout fake legal theories, but so you don't end up embarrassing yourself like this. The truth is, courts don't play with nonsense, even if the judge gives you a few kind words at the end. And let's be real. There was free legal help waiting for him. He just chose to ignore it and file the most ridiculous motion I've ever seen. It made no sense. The whole performance was like a lesson in what not to do in a courtroom. The law isn't some made-up adventure where you get to write the rules as you go, but hey, at least he gave us some top-tier entertainment today. That said, I think I was too generous earlier. I called his reading level 6th grade, but after that performance, 3rd grade might be more accurate. Anyway, if you enjoyed this breakdown, hit that like button, subscribe, and drop a comment if you have a court case you want me to cover. I post every day and always appreciate your support. Thanks for watching, and take care, everyone.